Everyone, welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. Today, I have the privilege of interviewing Matthew Dickstein, one of my esteemed, incredibly talented interns on a previous podcast. He interviewed me, grilled me, I'll say. But Matthew, welcome back.
Thank you. Well, thank you for having me on the podcast.
Today, we're going to discuss IP in daily life. I think that's the topic. And you're going to give us kind of an overview of the different types of intellectual property.
Yeah, so I kind of was just going to give an overview of all the different types of intellectual property that are available to people and also ways that they show up in everyone's daily life. Lots of,
Mm.
you see them everywhere you look in daily life, and there are a
Whatever.
lot
Well,
of
you're
things.
not even really thinking about it.
Yeah, yeah, you don't, something that you don't think could be intellectual property, and it's all around you.
I mean, I even know in like movies, you have to be aware of product placement and if you're using an Apple, whether you have to blur it out or whatever. People don't even think about some of that stuff. All right, let's talk about the first one. Let's go with trademarks.
Yeah, so
What would I got to know?
trademarks are a way of identifying brands. So they can be a word, a phrase, a symbol, a logo, and it's a way to identify where goods or services are from. Um, yeah, and so it identifies it, and once you start using a word or a phrase or a logo to identify your goods or services, you have a trademark through common law. And then you can later on register that trademark with the state or the US government. Um, yeah, and you can register it based on your current use in commerce or an intent to use in commerce.
So before you start using it.
Yes, so you could file to register it before you start using it, but you have to eventually be using it to keep that trademark.
But and then there are things that you don't really even think about. Sound marks. We did a little something on sound marks.
Yeah, so
Give us a
that's
couple of examples.
yeah, so some really interesting things that sounds that make people think of brands. And so, it's not a logo, but you hear the sound that a Netflix makes before an episode starts. So that's something that they have trademarked because it's a sound that makes you think of Netflix. Some other famous ones would be like the lion's roar. Um, uh, and then they even have smell marks, which like their Play-Doh has the smell of Play-Doh trademarked, which if you look at the registration, it's very interesting because you can't, you know, put an example of what it smells like up there. So like with the Netflix sound, you can listen to the sound with a word or a logo. You see the logo, you can see what the word is. But with Play-Doh, it just says that it's the smell of Play-Doh.
I think sometime in the future, the computers or whatever will be able to emanate smell, and they'll probably be able to deal with that issue. So let's get to patents.
Yeah. And well, so next patents are for inventions and things that you make. And so the two main things would be utility patents and design patents. So utility patents would be for inventions, things that people use, and design patents would be for more ornamental design elements that you can patent. And whereas a big difference with this is that you'll see in some of the other ones is that a patent is for a fixed period of time. So if you file for a utility patent, you only have it for 20 years from when you file, whereas a trademark can last forever as long as you keep using it and keep up with the requirements for it.
So sometimes you want to opt for either trademarks or trademarks and patents because, and we've discussed recently some examples of getting a design patent and a trademark, and therefore you may
Yeah.
get some broader protection with the design, but trademarks last forever kind of thing.
Yeah, and so there are
Theoretically.
lots of things that could both identify your brand and be like an ornamental design element that is specific to what you're using. And so lots of cars will have like a body shape being something that is trademarked and patented because it's a design element that's eligible for a design patent, but also it makes you think of the brand so you can get a trademark on it. Um And yeah, so with a design patent, you then have the patent over that design, but it's only for a fixed term. Whereas if you have the trademark over it, it can last for much longer. So lots of people opt to do both of them so that they can have better protection and a wide range of ways to protect it.
I mean, I'm guessing the Coke bottle, I mean, it's pretty distinctive. You can see it across the room and you know that's Coke. I'm sure they have a trademark on it, and I'm guessing they probably at some point early on filed for design patents.
Yeah, I'm not entirely sure of that exact one,
Okay.
but that would be along the lines of
All
something
right.
that
As
you
a
could see
concrete
happening.
example, whether it's exactly, but
Hmm.
along
Like,
those lines.
I know like certain car manufacturers, I forget the specific brand, but like the design on the body of the car manufacturers will have design patents on it, but some of them also have asserted common law trademark rights for them by saying that people see this car and think of their brand.
Yeah, makes sense. Sometimes you just see it and you go, "Oh, that's a Beamer," or
Hmm.
"Oh, I mean,
Yeah,
look at
very
things."
iconic cars like
Yeah,
a Mustang, like a Ferrari, a Lamborghini. People understand like the shaping of the car and immediately think of the brand that makes it.
right. Let's get to the next one. Copyrights.
Yeah, and so copyrights are uh protect something else, obviously. It's over original works of authorship or art, something that sort of art that someone created. And so whether that they songs, books, things that people have written or sung or performed, it could be dances, any sort of art like that. And so that has also a fixed term. And for a person that owns their own copyright, it is for their life plus an additional 70 years after they pass away. But then it's also different if something is unclaimed or anonymous or is owned by a corporation. For that, it's only 95 years from the publication or 120 years from its creation, whichever one is a shorter term. And it obviously has to be slightly different because if it's owned by a company, it doesn't work to have after they pass away another 70 years.
20 years should be generally long enough for most people to get that protection.
Yeah, yeah, I
I,
don't know of many people that live past 120.
I mean, I know for Mickey Mouse, it recently went into public domain, but that was under the old copyright law. And I think Congress specifically extended that to protect Mickey Mouse for a little bit longer.
Yeah, I mean, there are lots of very iconic things that it would make sense. Something like Mickey Mouse is, everyone knows what it is, so maybe having special things for that would make sense.
All right. And let's get to the last topic as far as intellectual property, we're going to discuss today, trade secrets.
Yeah. So trade secrets being the last type of IP we're talking about has something that's a little different from the other three things we'd already talked about. The other ones, well, some of them you get protections without registering them. With a trade secret, you don't ever register them. It's uh, by the name, it's a kept secret. So a trade secret is any information that is um that has a value by being secret and a business uses it and they make effort to keep it secret from other people. And the definition of what can be a trade secret varies based on state law and federal law, but it is in both cases something that has value by being secret.
And then,
Um,
yeah, I mean, I guess sometimes trade secret can cover things that patents don't cover, like
yeah, there are lots of
know-how,
things.
business lists. Uh,
Mhm. Yeah, well, like patents can't cover things that are like business processes, whereas a trade secret could be a business process if you keep it secret and it is valuable for how you do business. But there's also intersection where things can be both patented and trade secrets. And in that case, there's benefits to either side, and you kind of have to see what is better for you. Trade secrets don't have a definite term. So, like a patent, you only get the 20 years from when you file for it, whereas a trade secret could go forever as long as you keep having value from it and you keep maintaining it secret. And then another difference would be you have to pay for registration and fees associated with a patent, whereas there are no fees associated with a trade secret,
Well,
but
but you
it's
have
not
to do
always
steps,
cheap to keep the secret. Yeah,
right?
you
But
have to
you
make
gotta,
steps to keep the secret.
yeah, so that just sometimes costs some money.
Yeah.
I mean, it's the big,
And
yeah, big advantage, disadvantage, what's one big disadvantage?
one of the biggest probably the biggest disadvantage of the trade secret is that someone could reverse engineer your product. So if I, sell a product, someone could buy my product, take it apart, figure out how it works, and that's an acceptable form for them to then create it themselves now that they know how it works. Whereas if I had a patent on it, someone already knows how it works, but they can't make it anyway. Um,
Yeah, but even besides the reverse engineering, you also have an independent uh, design that you come up with or invention. I mean, you don't have to reverse engineer it, but since it's a trade secret, you if someone else comes up with the same thing, they're free to use it.
Yeah, that is also true. Yeah, anyone can use it as long as they don't get it from um misappropriation of your trade secret.
Right, but if a company accidentally blurts it out somehow, or sends an email, we know lots of stories about people sending out emails with "oops, I didn't know it was sent to so and so who's not in the company." So
Yeah.
like everything
So,
else, there's advantages, disadvantages to things.
yes.
All right, do you have anything to add in conclusion?
No, nothing to add, just that you know, between the four different types of IP, you need to always figure out what's right for you. And even when something can be more than one type of IP, only one of them might make sense, or multiple of them might make sense. And just depending on the situation, you have to determine what's right for you.
Well, thank you very much, Matthew. Uh, Very informative, a kind of general overview of the different types of intellectual property. And to all you out there, thank you for tuning in. And look forward to seeing you on the next episode of Unraveling Intellectual Property with Michael Stein.